Good morning, everyone. Good morning to the panel.
Morning. Good morning.
I'm the court master of this courtroom. Now, I would like to congratulate the teams for qualifying the octa-final round on behalf of the Nyaya Shastra team. And on behalf of Nyaya Shastra, I'll be here for your every query, every confirmations. I would like to inform you about the rules for this final round. The rules for this round is each team will be provided with 40 minutes of argument time over this final round, including there will be a rebuttal round. The teams are allowed to divide their speaking time according to their own convenience. However, the priority request is to please inform prior the beginning of the argument. And if there's any doubt, you can ask right now. Teams, do you have any doubt regarding the rules? If no, please drop a no in the comment box. Thank you. Now, I would like to know the speaking time estimated by the petitioner side of speaker 1 and speaker 2.
It is 20 minutes and 15 minutes for the speakers and 5 minutes for rebuttal.
I will be informing you before the time gets over, approximately around 3 minutes. With due permission of the bench, you may begin with your argument.
Yes.
The council seeks permission to address this honorable bench as your lordship.
Please.
Oblige your lordship.
For this, starting this quickly up to the facts.
The council is appearing for petitioner, and the facts of this case are: Ayan Qureshi is a 29-year-old cyber law researcher and a digital rights activist. He has published various research papers, participated in debates, and filed PIS challenging the constitutional validity of Project Nigrani. This project was launched by the state government in 2022 through an executive notification, and it is not backed by any statutory or legislative framework. On the night of 14 April 2023, Police Commissioner in the office chamber at Navapur Police Headquarters. And within 48 hours, the police arrested Ayan Qureshi, claiming that the case had been solved through data generated by Project Nigrani. During the investigation, it emerged that the surveillance data was gathered without judicial warrant or prior authorization. The session court upheld the conviction and sentenced the accused to life imprisonment under Section 302 of IPC, and the same conviction was upheld by the High Court. Aggrieved by the decision, the accused or the petitioner is filing SL3 under Article 136 of the Indian Constitution. Your Lordship is well versed with the fact that the Council seeks permission to begin directly with issue 1. Oblige your Lordship. Issue 1. Whether the warrantless mass surveillance conducted under Project Nigrani, implemented without any parliamentary or state legislation and without statutory rules under the IT Act or Telegraph Act, violates the fundamental right to privacy and personal liberty under Article 21 of the Indian Constitution. The term warrantless mass surveillance refers to the installation of cameras, automatic number plate recognition system, real-time access to telecom metadata, and predictive threat analysis. Because these surveillance measures are not specifically authorized by any statute, they do not include safeguards in case of violation, and they are not subject to upheld in the landmark case of Justice K.S. Puttaswamy versus Union of India. Along with it, it affects the right to freedom of speech and expression as guaranteed in the Article 19, Clause 1, Subclause A of the Indian Constitution, because Ayan Qureshi was a bona fide person who was an outspoken critique of Project Nigrani. He demonstrated his defiance by writing research papers and filing PILs. On the very
Counsel, I would like to interrupt. Sir, I would request you to please turn off your mic. Thank you, sir. Counsel, can you begin?
On the basis of being an outspoken critique, Ayan Qureshi was categorized as a high-risk threat by the AI predictive analysis that imposes the very threat to the democracy and its fundamental principle. Because challenging the constitutional validity of Project Nigrani was without any mens rea. It was just raising voice against the malpractices or the project implemented by the state. Project Nigrani was created through executive notification as there was no statutory backing. It operates without statutory limits and it lacks parliamentary scrutiny as it was not laid down before any house of parliament.
Madam, will you permit me to ask a question?
Yes, sir, you can.
See, you submitted that there is no statutory backing. Is there a notification or order of the state government?
That was a notification, executive notification, Your Lordship.
Executive power is it not sufficient under the constitution? What is the function of Article 73 you have referred?
Your Lordship, executive notification is sufficient, but in order to implement a project that includes mass surveillance, that too for a long duration of time, it does require statutory backing because it affects and it tracks 24/7 activity of every citizen. So it must be backed by any statutes, or even in the slightest, it must be laid down before the parliament in order to be constitutional in nature.
No, if it is a notification, will it not satisfy the requirements of Article 13.3.1? What is Article 13.3.1? You are on mute.
Article 13.1 deals with laws inconsistent with or in derogation of
Article 13.3.1.
Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law.
So that was the test. Then what is 73? Article 73.
Article 73 is extent of executive power of the Union.
Your basic challenge is that it is an action taken without the support of law.
Your Lordship, our basic contention is that the project violates fundamental rights, and if it is violating, then there should be reasonable restrictions. And not having statutory backing is one of the grounds, Your Lordship.
Article 19. Yes.
Just back to what Senior said. Just one clarification: whether the notification, executive notification, whether it constitutes a law or not, whether it has a force or not. What is your?
It is a bylaw, Your Lordship.
No, whether it is a law as a force of law or cannot be considered as a law. Just simple question.
It can be termed as a force of law. But the very same mass surveillance or the interception of data is categorized or derived the power from Section 90, Clause 3 of the IT Act, which states that if the state government is required to adopt certain measures in order to protect the integrity of the state, then that must be laid down before the House of the Parliament. My Lord, I would like to bring your kind attention to the landmark case of State of Madras versus Champakam Dorai Rajan, where it was held that states' responsibility as guided under DPSPs cannot override fundamental rights, or even if it does so, then there should be reasonable restrictions. As if the timeline of the event is to be traced in our case, the execution of Project Nigrani was a mere precautionary measure instead of an emergent one.
Madam, Madam Champakam Dharai Rajan was against communal order. And what happened to the judgment in Champakam Dharai Rajan? Subsequently, constitution has been amended. Okay, proceed.
The execution of this project was themed as a part of smart city and national security initiative solely, and not as an emergency arising out of the state's or union's territory. Moreover, the exclusion of factors such as what will be the duration of the surveillance, at what time will it be activated, or how does it work, is what imposing threat on citizens' liberty rather than protecting it. The 24/7 track of every citizen's activity in the state of Andhra Pradesh shifts it more towards the dictatorship and less towards the democracy, which is hampering the very principle as laid down under the landmark case of Keshwananda Bharati versus Union of India. The Council humbly submits that procedural safeguards are essential in surveillance regions under the IT.
Just to add, you said that you have admitted the fact that in matters of national security, the state can actually implement or conduct a surveillance. Can surveillance, can you term this surveillance of a person who has committed a murder as a threat to national security or not?
The Lordship, the surveillance which are threat to the national security.
Yes, no, surveillance can be carried out when there is a threat to national security. Now, can a person who is accused of committing a murder or commits a murder, can it be considered a threat to national security or not?
The Lordship, the very fundamental principle of this court of law, the rule of law states that accused must be presumed innocence until it is proven guilty beyond reasonability. The surveillance.
That is different. I am saying, I am asking you a simple question. Whether surveillance carried out by the state on the pretext of national security, right? So, a commission of murder, whether it falls under the definition of national security or not, can the state be permitted to conduct surveillance on the ground? Can it be justified in conducting surveillance on the ground that the person whom surveillance is carried out is accused or guilty of murder?
Yes, Your Lordship. If the terror is so long or so hardcore that it affects the very integrity of the state.
So that means to say you are admitting that the state was empowered to conduct surveillance.
Council, how do you determine whether the terror, whatever activity is happening, it is amounting to a larger terror, or it is just some person moving around? Like, only when you do the surveillance, you get to know whether this person is involved in any terrorist activity, isn't it? And that's the reason why the surveillance.
The petitioner is nowhere challenging the surveillance powers of the state. The petitioner's contentions are the surveillance.
Your petitioner has filed the PAs against the surveillance. You only have admitted that he has filed the PA before the High Court of Uttar Pradesh. Now you say that you are not challenging the surveillance power. Exactly, Project Nigrani talks about surveillance and he has been vocal upon it, but now you are saying he is not challenging.
The Lordship, the PIL that was filed was in regard to the detailed governance of the Project Nigrani. The executive notification solely implemented that the surveillance powers or the measures will be taken, but it does not state how long what will be the procedure of the same and the algorithm that categorize citizens on the basis of being a threat. The petitioner raised PIL in order to get a clarity on the same.
No, when you challenge an order or a decision or a notification through a PIL, you are making a substantive challenge. It is not a partial challenge. You cannot say that to that extent the challenge is not there, to this extent challenge is there. You are challenging the authority of the state to enact on the ground of violation of the fundamental rights, especially Articles 21 and Article 19.1.
Yes,
Article 19 provides for balancing power through reasonable restriction.
Yes, Your Lordship.
See, it is an equation between worth of man and unity of societies. So, unity of society must be given precedence over the worth of man. That is the essence. What is your answer to that?
Your Lordship, the reasonable restrictions guaranteed under Article 19, Clause 2 of the Indian Constitution states that the state or the union can take measure in order to prevent the integrity, security, or nation's governance within the territory of the state or the nation. But that restrictions must be reasonable and that must be carried out without any arbitrariness. The 24/7 mass surveillance and gathering or admitting the evidence on the same imposes a threat to the very principle of democracy.
No, how do you say it poses threat to democracy? See, democracy is a different thing. Democracy is by the people, for the people, of the people. So it is not something that state is restricting a person not to vote. Democracy essentially is the right of a person to choose or elect a person of their choice. It leads to governance. But how you are saying that it is violation of Article 19, right? You are saying essentially to put it, in fact, to put something, you are saying it restricts the freedom of movement, right? So how does it affect Article 19? How do you say this? The surveillance of this project violates Article 19. But fundamentally, if you are challenging the conviction, you also have to argue on the fact that it is itself is bad in law.
The Lordship surveillance powers includes AI predictive threat analysis that categorizes citizens on the basis of being a threat to the state itself, but there was no algorithm or the algorithmic process was not defined what the input will be so as to receive that certain kind of output. Now, if our petitioner is being categorized as a high risk on the basis of being an outspoken speaker, and outspoken speaking means filing PILs, research papers, or participating in debates challenging the constitutionality of any project or any other measure taken by the state. That is what the petitioner is contending, Your Lordship.
You are not
Counsel, I have a question for you.
Yes, Your Lordship.
Counsel, did I hear you correctly when you said that you have filed a PIL?
Yes, Your Lordship.
So you have approached the Supreme Court under which article?
Article 136 of the Indian Constitution, Your Lordship.
Would you still say that you have approached the Supreme Court in a PIL?
We have not approached the Supreme Court under PIL. The jurisdiction of approaching the Supreme Court is derived from SLP as guaranteed under Article 136 of the Indian Constitution. However, PIL was another initiative taken by the petitioner in order to challenge the constitutionality of this project.
And can you tell me what are the grounds for approaching the Supreme Court under Article 136?
Yes, Your Lordship. Substantial question of law, Your Lordship. If there was a grave injustice, miscarriage of justice, or the substantial question of law is remained, then the petitioner or any other citizen aggrieved by the decision of the lower court can approach Supreme Court under SLP or granted under Article 136 of the Indian Constitution, Your Lordship. As it was also laid down before precedents of this case. Before precedents of other cases, Your Lordship.
Counsel, what are your prayers?
Yes, Your Lordship.
Just quickly tell me the reliefs that you are seeking.
Your Lordship, we are seeking rejection or modification of the decision of Session Court and High Court and overturn conviction of Ayan Qureshi for the offence of committing murder under Section 302 of IPC and should not be given any penalty, and to exclude the impugned evidence and issue constitutional guidelines governing digital surveillance and preventive policy.
Madam, in an SLP, in a special leave petition, what ought to be the prayer? Prayer should be for granting leave.
Yes, Your Lordship.
Instead of that, you have embellished your prayer with all sorts of praise.
Your Lordship, in the previous hearings, Supreme Court has already granted leave to this SLP. So this becomes the appeal, and that is why these contentions are mentioned in the prayer, Your Lordship.
Counsel, you are essentially appealing against a conviction order in a criminal case. Is there any other provision of the Constitution that you could have approached the Supreme Court under?
Yes, Your Lordship. Article 134 says the appellate jurisdiction of this Honorable Supreme Court.
And why did you choose not mentioned in the one.
Your Lordship, when the High Court upheld the conviction, there was grave injustice and violation of petitioner's right. That creates urgency for the matter to be heard. That is why this petitioner has filed SLP under Article 136 of the Supreme Court. And in addition to that, Article 134A certificate was not issued by the High Court. So that leaves the only option to be heard, following the principle of natural justice, Your Lordship.
Alright, thank you.
If Your Lordship is satisfied, then the Council seeks permission to kindly begin with proceedings.
Council, just one more question.
Yes,
How
Your
much
Lordship.
surveillance do you think was apt in this case? Because you said to some extent surveillance would have been all right. So could you tell me how much? Can you quantify that?
Your Lordship, in our case, surveillance measures include CCTV footages that are applicable because it monitors and it captures whether the citizens are engaging in any threat-posing activity or not. Second, it governs with telecom metadata. And third, it has AI predictive analysis. AI predictive analysis is a technological evidence that questions the very existence of being admitted in the court of law or not. And the surveillance measures are applicable and valid or justified to the extent as it does not violate fundamental rights of the citizens.
Yeah, what extent is that?
Your Ladyship, if 24/7 monitoring of citizens' activity is done by state, then we do not know how the data will be calculated or will be assessed or transferred. There were no guidelines in regard to that. If the guidelines or the constitutional principles in regard to the same will be implemented or will be notified, then to that extent surveillance measures are applicable and they are valid and justified. But in our case, Project Nigrani does not have any guidelines for the same.
Just to add on from what ma'am said, you said that there is digital evidence. You talked about digital. So using AI, I collect that the state collects the digital evidence and presents it to the court. Do you think this digital evidence itself is unconstitutional? So the state cannot present digital evidence before the court?
No, Your Lordship, we do not claim that. The state can very well present digital or technological evidence in the court of law, but the admissibility of the same is to be challenged. And digital evidence, yes, Your Lordship.
No. I'm just saying that you said that the digital evidence, because it uses the ground for challenge of this project Nigrani was that it uses AI, and using the AI algorithms, the evidence is collected, so the digital evidence is collected, and based on this digital evidence, this is present before the court. I'm just interlinking the entire project with the conviction of your client, that is the petitioner. So tell me, wasn't the state justified because you are submitting the fact that it is the prerogative or the state has the right to collect digital evidence, and based on the digital evidence, a conviction is sought. So we are going to the root of the matter where the digital evidence that is so collected is admissible or not.
Your Lordship, the digital or the technological evidence that was collected and presented before this honorable court includes that facial recognition cameras that allegedly captured the petitioner near the police headquarters, only in the vicinity of the police headquarters, shortly before the estimated time of that. That is also not certain. Telecom metadata placed his mobile device in the vicinity of headquarters. Again, that is also not certain. And the predictive policing algorithm classified him as high-risk suspect based on behavioral and online activity analysis, Your Lordship, and excluding or admitting evidence which do not form a concrete chain of evidence is what being challenged, Your Lordship.
Excuse me, Lordship. Hello. I would like to inform the bench that the time given for the speaker one of the council is already up. Okay.
The council seeks permission to just conclude with the arguments of this issue 1 and issue 2. Much obliged, Your Lordship. The present evidence is derived from unconstitutional mass surveillance. The petitioner had no control or consent over it. Also, it has no legality of the subject matter. There is no legitimate aim. Necessity of passing it was not there, and proportionality along with procedural safeguards were not upheld. And Project Nigrani has no. Yes, Your Lordship.
Please go ahead.
Counsel, under the laws of India,
Yes, Your Lordship.
is there a differentiation between evidence collected through lawful means and evidence collected through unlawful means? Does the law and the judgments of the courts of record, do they differentiate between these two types of evidence?
Your Lordship, in the very case of Selvi versus State of Karnataka, it was held that evidence or the conviction or evidence which are taken by the accused or the petitioner without their consent is illegal, and it affects the very fundamental principle of the same.
No, Selvi is a different proposition. Selvi talks about the voice sample or the narco analysis, narco analysis test without the consent of the accused. Evidence is different. Section
Yes, Your Lordship.
2H of the CRPC says investigation means collection of evidence. And what my brother actually asked is a simple question: whether evidence that is lawfully or unlawfully connected or illegally obtained, can it be used as evidence in court or not?
Yes, Your Lordship, if it established the principle of relevancy and reliability, Your Lordship. It was already upheld in various precedents, Your Lordship, that if the evidence can satisfy the test of reasonability and relevancy in order to establish a circumstantial chain and a concrete evidence to prove the guilt of the accused or the petitioner beyond reasonable doubt, then that can be admitted.
Madam, in
Does
your
relevancy translate to admissibility? Sorry.
that's all right.
So, can relevancy always lead to admissibility of evidence?
Yes, Your Lordship, if the evidence is relevant enough to prove the guilt beyond reasonable doubt, then that can be admitted in the court of law. But that must also be assisted by other evidences. It cannot be solely relied upon. There must be other.
So all relevant evidences are admissible.
No, Your Lordship, not all relevant evidences.
All right. So please.
You have not referred to your memorial during the course of your submissions.
Your Lordship.
Madam,
Yes, Your Lordship.
you have not referred to your memorial while making submissions. In which part of the memorial you have dealt with this unconstitutional mass surveillance?
Your Lordship, it is mentioned under page number 17, para 2.
Read one sentence.
Your Lordship, it states that it is submitted that unconstitutional mass surveillance stands for the recording of citizens' every act across the state without their consent or emergence of doing so. The surveillance.
How can you call it unconstitutional? Who is to decide whether it is constitutional or unconstitutional?
This honorable bench, Your Lordship.
Okay.
The petition. Lordship. The petitioner seeks permission to begin with further proceedings of this case, Your Lordship.
Thank you.
Oblige, Your Lordship.
Your Lordship, the Council seeks permission to begin with issue 3 and 4.
Please.
Much obliged, Your Lordship. Issue 3, whether the use of algorithmic profiling and predictive policing violates the guarantees of equality, due process, and non-arbitrariness under Article 14 and 21 of the Constitution. Your Lordship, the Council on behalf of the petitioner humbly submits that the use of algorithmic profiling and predictive policing under Project Nigrani by the state in the guise of public interest violates Article 14 and 21 of the Indian Constitution, as it permits the state to classify individuals as high risk through opaque and unaccountable technological processes. This program effectively allows suspicion to be generated by undisclosed algorithms rather than concrete evidence about Ayan Qureshi conviction, Your Lordship. Your Lordship, there has been a clear violation of due process by the state under Article 21 of the Constitution, as there has been unregulated and opaque deployment of algorithmic profiling by the state. The Project Nigrani introduces a system where individuals are classified, monitored, and effectively treated as potential offenders solely based upon undisclosed computational methods and based upon understood computational methods and predictive analytics without any legislative framework, procedural safeguards, and authenticity. And this kind of system alters the nature of criminal justice from one being based upon the proof conduct to the one premised upon predictive suspicion, Your Lordship. Likewise, in our case, as the facts clearly state that there was no eyewitnesses, the weapon was not recovered, the agitator showed no signs of.
Counsel, I have a question for you.
Yes, Your Lordship.
Counsel, the reasonable restrictions under Article 19, are they applicable only to Article 19 or to other fundamental rights of Part 3 as well?
To other also, Your Lordship, but it should pertain to at least what have been mentioned under Article 19 clause. So, like it should be seditious, whatever is being spoken, like in Article 14 and Article 19, freedom of speech and expression is guaranteed to us. But any kind of debates or research papers or any kind of spoken out critics by the Ayan Qureshi were not seditious in nature or threatening the national interest.
Counsel, in which judgment was it held that the reasonable restrictions under Article 19 are applicable to other provisions?
Yes. Just a minute. Your Lordship, under Menka Gandhi versus Union of India, the court held that the procedure established by law violating the fundamental rights must be fair, just, reasonable, and connecting the golden triangle of the Indian Constitution, that is Article 14.
Not my question. Not my question. My question is, you said that the reasonable restrictions under Article 19 are applicable to other fundamental rights as well. Other fundamental rights can also be curtailed under the reasonable restrictions. Which judgment held that?
Your Lordship, the Council does not have information on this. Seeks apologies.
All right. Proceed.
Just to add on from what you said. You were talking about pertaining to the facts of the case. You were talking about his speech not being seditious. Nowhere he is being targeted for his speech. He is accused of murder, and in fact, he is convicted based on Project Nigrani, that is a surveillance mechanism. So
Yes.
please address on that as to how this Project Nigrani itself is bad or unconstitutional.
Yes, Your Lordship, but dissent is not being sedition, and it has been clearly stated, like according to the fact that
No, he is not convicted for dissent. He has been surveillanced, and there has been evidence that has been found out against him. Incriminating material was found against him, which
Yes.
was used, and that is why the courts have convicted him. So
Yes,
he's
Your
not
Lordship.
said anything.
But
Not-
yes, Your Lordship, but according to the facts, it has been stated that the behavioral and the online activity analysis have also been taken into consideration while commuting to this conviction of Ayan Qureshi.
That
And
is
none of
not
the
dissent. That is not dissent per se. He is not convicted for dissent. His behavior analytical shows there is a potential high risk. Okay,
But-
highly risk because of his online activities, which shows that he is capable or he is guilty of that murder or indulged in that act.
Yes, Your Lordship, but none of his behavior is showing, like doing research papers or going into the debate or speaking publicly does not show any kind of being seditious or dissentful in nature. And along with it,
Dissent, no, you are confusing dissent with surveillance, because dissent is something he is speaking against something. But here he is not convicted. His conviction is not based on his dissent. Rather, his conviction is that he murdered someone, and the reason was that there was some material or the online material available. So, which according to me is perfectly right. Don't
But
tell
Your
me
Honor-
why I am wrong.
But Your Honorable, though no concrete evidence is there, it is just a mass surveillance, as it is being said, it is generalized, and if they are containing it is not specific, then how come they are coming upon Ayan Qureshi specifically and telling it is a semi-public or public area, and anyone can be a Nagpur police station headquarters is a very public and semi-public area. Every person can be around there. Just approximity and being in there and around the place, how can they claim to be Ayan Qureshi to be the convict? And any kind of behavioral, what kind of behavior and online activities have shown that he is doing that? Is PIL filing as any kind of sedition in nature or any kind of behavior activity which is against the nation?
Madam, investigating agencies have found clinching evidence.
Yes.
And do you mean to say that digital evidence is inferior or subordinate to other classes of evidence?
No, Your Lordship. With all due respect, it is allowed and it is eligible. But, Your Lordship, the data, the surveillance data that has been collected, it is without judicial warrant or prior authorization.
You are referring to Golden Triangle.
Yes, Your Lordship.
Which authority has stated that? Golden Triangle.
Your Lordship, the Honorable Bench has said it in the Supreme Court.
Madam, is it Golden Triangle or Golden Quadrilateral?
Golden Triangle, Your Lordship.
Which are the articles coming?
14, 19 and 21, Your Lordship.
Why can't you make it quadrilateral by including Article 32?
Yes, Your Lordship, but isn't it pertaining, isn't it curtailing our very motive?
Okay, thank you, ma'am. Proceed.
Much obliged, Your Lordship. Your Lordship, along with it, I would also like to highlight the landmark case of Mendha Gandhi versus Union of India, where the constitutional judgment was established that any state action affecting personal liberty must be just, fair, reasonable, and not arbitrary. Your Lordship, the Council further submits that the use of algorithmic profiling violates Article 14, as Project Nigrani is clearly challenging arbitrariness and lacks transparency. Also, it is an established principle that arbitrariness violates Article 14 as held in the landmark case of E.P. Royappa versus the state of Tamil Nadu, where the Honorable Supreme Court of India held that equality is antithetical to arbitrariness. As hereby, Your Lordship, I would like to state and draw your attention that firstly, the algorithm used for predictive policing operates on undisclosed parameters. Secondly, there are no publicly criteria for classifying a person as high risk, as they have been identified Ayan Qureshi as a high-risk potential offender in the society. Thirdly, the decision-making process is completely opaque and baseless. Thus, the classification lacks any kind of intelligible differentia and fails the test of reasonable classification under Article 14 of the Constitution. Also, Ayan Qureshi was flagged as high risk based on behavior and online activities solely. No concrete evidence linked him directly to the crime, and the system effectively treated him as suspect before any offense was proven. Henceforth, this violates the presumption of innocence, which is a core component of fair trial, Your Lordship. Your Lordship, the Council further submits to the Honorable Court that the algorithmic governance without safeguards leads to unchecked state power infringing Article 14 and 21. As this project lacks independent oversight, there are no audit mechanisms in order to maintain the authenticity of the project, and lacking legal standards, which leads to the denial of due process and natural justice. Your Lordship, if you're well versed with issue 3, shall I begin with issue 4?
Please go ahead.
Yes.
Much obliged, Your Lordship. Issue 4, where the reliance on secret technological surveillance and algorithmic evidence has violated the petitioner's right to fair trial and warrants interference by the Supreme Court with the concrete findings of the conviction. Your Lordship, the Council on behalf of the petitioner humbly submits to the Honorable Court that Project Nigrani is unconstitutional because it exceeds the legislative competence of the state of Dakshin Pradesh disregarding the laws that have been laid down in the Indian Constitution. It is an unconstitutional surveillance program as it operates within a field that lies exclusive legislative competence of the Union. That is, firstly, the telecommunication interceptions and the digital data transmission falls under entry 1 of this law as being clearly distinguished as stated under Article 246 of the Indian Constitution. It is a settled principle that entries in the Union list must be given the widest amplitude. In the case of ITC Limited versus Agriculture Produce Market Committee, where the Supreme Court held that the state cannot, under the guise of public order, assume powers constitutionally belong to them. Therefore, the program is ultra virus of the Constitution, and the petitioner has been wrongfully arrested, violated his right to the petitioner enshrined under Article 14.
You have said that Article 246 gives the power for the state to formulate the laws. So, therefore, don't you think that this project Nigrani is being formulated, or the notification that was issued falls exclusively under Article 246? So, the legislative competence was already there.
Yes, Your Lordship. Under Article 246, it permits the state to do so, but as per Article 19, Clause 3 of the IT Act, it is being stated that at least it should be presented either one of the houses of the Parliament, and only then it could take place upon the state's legislature.
I'm sorry, Article 19.3 of the IT Act says so.
Section
19.3.
Section 90, Clause 3. Yes, Your Lordship.
Right.
Much obliged, Your Lordship. The Council humbly submits further that the present case is entirely based on circumstantial evidence supplemented by technological and algorithmic inputs without any direct or conclusive proof linking the accused to the commission of the offence, and such a conviction is legally unsustainable and contrary to well-settled principles of criminal law, as the prosecution must establish a complete and unbroken chain of circumstances that points only to the guilt of the accused, as laid down under the landmark judgment Sharad Birdi Chand Sarda versus the state of Maharashtra. Your Lordship, I would like to state here the 5 golden principles which need to be completed, which is punchil of the circumstantial evidence, which are as follows. Firstly, the circumstance.
Before we present the principles, can you briefly tell us what was this case about?
Yes, Your Ladyship, the accused was being charged with the murder of his wife by administrating potassium cyanide, that was a poison. The prosecution alleged that he wanted to get rid of his wife because he was interested in some another woman. Since there was no direct evidence, the entire case was based upon the circumstantial evidence. So the Supreme Court here held that the prosecution failed to prove the important links for the chain to be completed of the circumstantial evidence, such as an exclusive possession of the poison by the accused, an exclusive opportunity to administrative. Therefore, the court gave the benefit of doubt to the accused and acquitted him for the same. Your Lordship, you're on mute.
So there is another case mentioned here, ITC Limited versus Agriculture Produce Market Committee.
Yes, Your Ladyship. Yes, Your Ladyship. Here, it is that the state on the sale and purchase of the tobacco, it was being taken. The Tobacco Board Code Act 1917-5 under the Union control, it was being given. So here clearly it was being distinguished the powers to be that the Supreme Court held that the state cannot, under the guise of public order, assume that powers have been constitutionally provided to them.
Now, as per what you have said in 96 judgment, it says that state cannot assume the powers of union. Here, that is not a disputed law. Union or the state is not disputing. It's a power of the government. They have exercised their power, issued an executive notification. So that power, nobody is challenging. It is you are actually saying that judgment says the state usurping the power of the union, which is not your case.
Yes, Your Lordship, but it is stated like the state was with the Union Home Ministry Affairs. It was along with that the notification was being taken. So it was not presented to the Parliament. That is how we are trying to contend that.
No, but this judgment, I don't know how it is because it only talks about the powers. The state usurping the powers of union. But it is not your case. Your case is against the state implementing a project.
Shall I begin further? Much obliged, Your Lordship. Your Lordship, the Mayor present, Your Lordship, I would like to say the 5 principles of the relevant case. That was first, the circumstance must be firmly established by relevant evidence. Secondly, the facts proved must be consistently with the hypothesis of the guilt. Third, the circumstances must be conclusive in nature. Fourth, they must include every possible hypothesis except the guilt. Fifth, and the most important, there must be a complete change, leaving no reasonable doubt. Your Lordship, here the Mayor presence at the scene is not sufficient, hereby that the prosecution is solely relying upon the facial recognition, placing the petitioner near the location, and secondly, the telecom metadata showing only the proximity. And it is not sufficient to establish guilt, as also laid down under the case of Kali versus the state of Madhya Pradesh, where the Supreme Court held that the suspicion, however strong, cannot take place of the proof. As here, Navapur Police headquarters is a public, semi-public court, and physical presence or the presence of any kind of belongingness, such as the mobile phone and its vicinity, does not establish any kind of emotive, object exclusivity and the commission of the act. Thus, the evidence to any kind of conclusiveness linked to the commission of the crime. Alongside, the algorithmic process remains secret in the case. As Your Lordship, here Ayan could not know what data was being used, how the algorithm reached its conclusiveness, whether the data was biased or inaccurate, whether they were false positives, and whether other suspects were being excluded. As a fair trial requires that the trial
of the Lordship, I would like to inform the Council that your time is already up.
Your Lordship, I just seek 2 minutes to conclude.
Yes.
Much obliged, Your Lordship. Your Lordship, as a fair trial requires that the accused must know the exact case, the facts, and the charges against him. But here the trial becomes unfair, as where both the Session Court and the High Court, with all due respect, gave excessive weightage to technological evidence, mainly because it's scientific and which greatly violates the principle of fundamental rights. Your Lordship, if you are satisfied with the contentions of the proceedings, the Council seeks permission to proceed with the prayer.
See, you are emphasizing on a fair trial.
Yes, Your Lordship.
Fair trial vis-a-vis the technological evidence, scientific evidence. So, going by your arguments, the result of a DNA test is not acceptable.
It is, Your Lordship, with all due respect, it is acceptable, but along with the other evidences also, it is just a circumstantial. And how are we so responsible and depending upon the AI?
No, you have no right to know the configuration of the equipments used for this.
Yes, Your Lordship.
In a chemical analysis also, you don't have any access to the laboratory. You have access only to the result of the analysis.
Yes, Your Lordship. Your Lordship, but here, how come we know that the cameras are being not used beyond the decibel restrictions and stuff?
Why should you have such an apprehension? Why should you not think that it is correctly used?
Your Lordship, it is costly, but it must be let down before this honorable bench, and it should be known to at least the honorable bench.
See, human individual freedom and dignity, everything is subordinate to the security of the state.
Yes, Lord.
If only state exists, you can exercise your freedom. When the very foundation of your activity is against the state, I think, yes, you can conclude.
Yes.
On one hand, you have just one individual's right that you are trying to protect,
Yes,
while
that
you're
is
talking about
correct.
rights of all the other citizens in this country. You have to ensure their safety.
Yes, Your Ladyship. Like in the traffic police scenes, there are cameras installed all over the state. We know that there are guidelines, there are statutory framework. It is being let down to us. We know that there are guidelines and they are capturing us. We know that, but no such guidelines was being given under Project Nigrani to the individual.
But nearly in absence of guidelines, will it make it unconstitutional? See, it is more a procedural defect. Even agreeing with what you say, it's a procedural defect. Can a procedural defect be held as unconstitutional? At the most, whatever you say, even if I agree, it is only a procedural defect. Can a procedural defect be termed as unconstitutional?
Also, it might be subsequently cured also, the loopholes that you mentioned.
Madam, you know, the Supreme Court has held that procedure is only a handmaid of justice, not the mistress of justice. You cannot challenge the ways of a notification or order, making contentions against the procedure adopted alone.
The council, do you think that if this technical difficulty has been cured or the loophole has been cured, do you think that we should go ahead with this project?
Your Lordship, if proper statutory, then the entire case would have been overturned if everything was being provided and if there were no loopholes, there were proper guidelines, there were proper reasonable restrictions being let down as to how the behavioral patterns are being used and to what extent the restrictions are being there. Then it could have been, then the entire case would have been overturned. And
no, let us say that this, this issue has been resolved, and subsequently they have resolved and they have cured this disease. Let's say, do you think the current project will be all right to be applicable to the public?
Yes, Your Ladyship, if it is being done, if everything is so accurate and there is concrete, everything is being done.
Nothing is accurate. We cannot go for accuracy here.
Yes, Your Ladyship, because in the present era,
we can to some extent make sure that the possible restrictions can be laid. If the restrictions have been laid out now, do you think the current project is to be applicable and it is right?
Your ladyship, with the present day era, as everybody is using telecom and internet and other online resources, then it becomes legible. What to say? Your ladyship, with the mission, shall I begin with the prayer? Wherefore, in light of the issues raised, arguments advanced, and authorities cited, the Council, on behalf of the petitioner, humbly pray before this Honorable Supreme Court of India may be pleased to first reject or modify the decision of Session Court and High Court, overturn the conviction of Ayan Qureshi for offence of committing murder under Section 302 of Indian Penal Code and should not be given death penalty. Second, exclude the impugned evidence and issue constitutional guidelines governing digital surveillance and protective policing, and or pass any other order, direction, or relief that it deems fit in the largest interest of justice, equity, and good conscience, all of which most humbly is submitted and respectfully prayed. It was pleasure arguing before this court, your lordships.
Just one thing, in your prayer, I have a small problem. You argued for an acquittal, but in your prayer, you only said that it should not be given penalty, which means to say you are agreeable for the conviction of the petitioner. So please read your prayer. You have not talked about acquittal of the petitioner. You only say, I say vote on the conviction. So, which means to say, there is no specific term that is being used that, acquit the petitioner.
Your lordship, but overturning the conviction would acquit him for the same.
No, overturning the conviction will not automatically, lead to acquittal. Because
and even if you just to add to what my brother said, even if you do overturn the conviction under the offence of murder, other offences including culpable homicide not found guilty murder still remain.
Correct.
And essentially you would doom your client to a lifetime in jail, if not the news.
Apologies seek, your lordships. It will be taken into consideration.
Madam, you are before Constitution bench answering the references. The bench may answer the reference and send it back to the original bench for deciding the appeal. What is your prayer for the references made? Could you understand my question, madam?
Yes, your lordship.
What is your specific contention regarding the 4 references made?
Yes, your lordship, we want to reject whatever the conviction has been made, as it is getting too long and it has been arrested. Ayan Qureshi has been arrested.
No, you have not addressed that in depth. Okay, thank you.
Thank you.
Pleasure, lordship.
With due permission of your lordships, I would like to know respondent side, your estimated time for your argument.
17 minutes for speaker 1, 18 minutes for speaker 2, and 5 minutes for you.
17 minutes and
18 minutes.
18 minutes and 5 minutes for the rebuttals. With due permission of your lordships, you may begin with your argument.
May it please this honorable court, at the outset, I seek kind permission of this honorable bench to address it collectively as your lordship.
Yes, can you just quickly run through the facts?
Yes, your lordship. Your lordship, on April 14, 2023, police commissioner Rajiv Malhotra was found dead in his high security office chamber, the single record. There were no witnesses, no entry, and no weapon was ever recovered, necessitating the advanced investigations. Nigrani was introduced in 2016 as a national security initiative in collaboration with the Union Ministry of Home Affairs. The program operates effectively within the existing framework. It was implemented through an executive action or notification to address the urgent public safety needs. Qureshi was a cyber law researcher and a vocal critic of Project Nigrani who had filed a public interest litigation against the state. Within 48 hours, the police arrested Qureshi based on data placing his facial profile near the headquarters and his mobile device in the vicinity of the time of death. The surveillance data was gathered without prior judicial authorization due to exigent public safety needs. However, the petitioner was given a full opportunity to challenge the algorithmic processes during the trial. Both the Sessions Court and the High Court found the technological evidence reliable and admissible, leading to a conviction under Section 302 of IPC. This Honourable Court has granted special leave under Article 136 to decide the substantial constitutional question. If you may allow, my Lordship.
Yeah, please start.
Much obliged, Your Lord. I, Aditi Agarwal, appearing on behalf of the respondents in the present matter, I will be addressing issue 1 and 2, and my co-counsel will be addressing issue 3 and 4. Issue 1 and 2, namely, whether the project Nigrani is unconstitutional and whether the evidence obtained pursuant to it is admissible. Your Lordships, it is respectfully submitted that Project Nigrani is constitutionally valid and does not violate Article 14 or 21. With your Lordship's permission, I will address this issue under 3 subheads. Executive action is constitutionally permissible and not barred in absence of legislation. The project satisfies the constitutional test of privacy and proportionality, and the state has acted within the framework of existing statutory powers and public duty. Dear Lordships, the petitioner's primary contention is that the project Nigrani is unconstitutional merely because it originates from the executive action. With utmost respect, this contention is legally unsustainable. Under Article 73 and 162 of the Constitution of India, the executive has the power to act in all fields where the legislature is competent, so long as such action is not contrary to any existing law. Your Lordship's absence of legislation does not mean absence of power. In this present case, the executive has acted in response to a grave criminal situation, as also recorded in the said proposition. There were no witnesses, no weapon was recovered, the chamber showed no signs of forced entry. The incident triggered widespread public outrage and immense pressure on the law enforcement authority. Your Lordship, this clearly demonstrates that the investigation had reached a critical dead end, and the state was confronted with both evidentiary failure and urgent public pressure to ensure accountability. In such circumstance, the state cannot be expected to remain a silent spectator. The Constitution does not mandate executive inaction in the face of serious threats to public order. As also submitted in our memorial, page number 30, the project Nigrani is not a replacement of law, but an extension of investigative functions, which is necessitated by the evolving technological realities. Your Lordship, the petitioner relies heavily on the right to privacy as recognized in Justice K.S. Puttaswamy versus Union of India. The respondent does not dispute that privacy is a
Counsel, I have a question for you.
Yes, Your Lordship.
Which was the case wherein the right to privacy was first discussed by the Supreme Court?
Thank you for the question, Your Lordship. If I may take a moment. Your Lordship, from my perspective, the case was MP Sharma versus Satish Chandra, where it was a judge bench, and basically the case involved a challenge to the power of search and seizure, and the court held that the Indian Constitution does not explicitly protect the right to privacy. Yes, Your Lord.
Have you referred to this judgment in your memorial?
No, Your Lordship. We have referred K.S. Puttaswamy because it is a recent case. And also because it ultimately
which year was K.S. Puttaswamy pronounced by the Supreme Court?
2017.
All right,
That is
proceed.
the Your Lordship.
Just to add on, when we talk about the privacy judgment, you also quoted in your memorial, Karan Singh's judgment. Do you know what the facts of Karan Singh's judgment are?
Yes, Your Lordship.
Can you please tell me?
Your Lordship, this case basically there was a suspect in a decoy case and to intense surveillance. But the underlying ruling was that the case limited the police surveillance powers and it ruled that the night domicile visits is violative of right to life. But it also states that the personal liberty includes the protection against arbitrary physical interference. My lord.
So, doesn't the Project Nigrani fall foul of this judgment?
My lord, in this particular judgment,
Yeah, please.
my lord, in this particular judgment, as I also quote in my memorial, that only the measures like domiciliary visits were struck down, but the other form of surveillance for crime prevention was upheld by the court. If I may proceed, my lord.
No, other forms that does not include surveillance. See, this Project Nigrani is actually surveilling the person and also giving data and inputs, or it is judging a person. Essentially, it is not just providing information rather than judging the person. That is what is their argument. And correction clearly applies to the facts of the case, where the surveillance action by the government falls foul, and you cannot merely convict some person based on the surveillance. How do you justify the surveillance just because of an executive notification, that too in absence of any statutory law, and you are saying that it was an urgent need? So, so when such is the pressing necessity, why was he surveyed, and why was he convicted? This, in fact, the surveillance itself is wrong in law. As per correction.
Thank you so much for the
See, in fact, Puttaswamy judgment goes one step ahead to correction. So, how do you harmonize these two judgments, correction and Puttaswamy, to justify the surveillance?
Thank you so much for your question, Your Lordship. I would like to answer the particular question while stating that the Project Nigrani does not involve entering the private homes or physical interference in any perspective. It relies on the public space facial recognition and telecom metadata areas where the court held that surveillance for the prevention of crime is permissible. And also, my lord, the surveillance in Khadak Singh was struck down primarily because it was based on the police regulations, which did not have the force of law. While Project Nigrani, as I will also state in my further arguments, Project Nigrani is backed by Section 5 Clause 2 of the Telegraph Act and Section 69 of the IT Act, where these are the parliamentary statutes that provide the procedure established by law, which is required by Article 20. If I may proceed, my lord. Much obliged. The respondent does not dispute the privacy is a fundamental right. However, it is equally settled that this right is not absolute. This honorable court laid down a proportionality framework requiring legality, equity.
Madam, one question. When you say that his right is not absolute, your power is also not absolute. Having put in place a scheme, a project, you are investing the officers with power. How do they use the discretion? Is it not excessive discretion? It is one thing to have the power of a giant and another thing to use it like a giant. Have you not exercised your power beyond the scope of jurisdiction conferred on?
Thank you so much. I would like to answer the Lord by stating that I entirely consider that the court's power is not absolute. Also, in the constitutional democracy, no branch of government possesses the absolute power. However, there is a fundamental distinction between the absolute power and the legitimate sovereign duty. The state's authority to implement the Project Nigrani is not an exercise of will. It is basically the fulfillment of the constitutional obligation to protect the right to life of its citizen under Article 21. While the individual's right is restricted in this particular scenario, the state's power is simultaneously contained by the very statutes that authorize it, like I mentioned as well, the IT Act and the Telegraph Act. While, my lord, we are not asking for a blank check. We are asking this court to recognize that when the state's power is exercised, it is basically under the law passed by the parliament itself.
When you have an entitlement for exercise of power, there is a corresponding obligation to be fair. duty to be fair, fairness in action. Don't you think that you have not violated the, don't you think that you have violated the principle of fairness here while making choices?
Your Lordship, for the question, as I will also state this particular instance in my second issue, but I would like to answer by stating that the duty to be fair is violated when the state action is based on a whimsical or a prejudiced human intellect. While Project Agrani satisfies the mandate of fairness by basically substituting the subject human or with a basically statistically neutral algorithm. The algorithm basically applies on the constant logic to every data point, which ensures that the petitioner was treated with the same impenetrable standard of basically objectivity. And also, my lord, the fair trial under Article 21 basically does not require the exclusion of the relevant evidence. Rather, requires that the accused be given a meaningful opportunity to contest and test that evidence. And also, my lord, Captain Maneka Gandhi, the procedural fairness must be understood in the context of this particular state is important. And when the highest law authority officer is basically attached inside a high security installation, fairness to collective safety of the republic, it outweighs the absolute openness of the investigative parameters. And thus, my lord, a procedure that generates a real-time intelligence leads to stop a sophisticated perpetrator from escaping its strictly just, fair, and reasonable, which is under Article 21. And thus, have not acted outside the law. We have operationalized under the safeguards, which is already mentioned under the respective provisions and sections of the particular law. Yes, my lady.
Patil, could you let me know which was this case where telephone tapping was held to be illegal?
Yes, my
Under
lady.
emergency circumstances.
If I take a moment, my ladyship. My ladyship, if I may refer to the landmark case of People Union Civil Liberties versus Union of Indica, where the facts of the case was that it challenged the constitutional validity of the Indian Telegraph Act, which I've also mentioned in my memorial, which it alleges that it was being used by the executive to tap phones of the politicians and activists without any procedural safeguards. My ladyship.
Okay. Can you now tell me what is real-time telephone data interception?
Yes, your ladyship. Your ladyship, the real-time telephone data interception basically means or it is process. Third party.
Sorry, I think there's some disturbance.
If I may proceed, my ladyship.
Yes, please.
Real-time telephone data interception basically is a process where a government agency or any third party assesses the telecommunications data as it is being transmitted. In the context of our case, it is basically a digital.
You mean the live recording of the telephone conversations?
Yes, your ladyship.
So, is that allowed? Referring to the previous case that you just mentioned?
Although, your ladyship, real-time interception is legally and technically kind of a little distinct from the live recording aspect.
How different? Because here, live, real-time, the telephone tapping was only about the recording of the voice. Here, this involves reading the messages, SMSs, the live monitoring basically.
Yes,
and it is mostly because in your case it is unlawful as well. It is like completely taking all the data, that is all the calls and messages etc. being recorded live.
Just to add on, it also understands or studies the behavioral aspects. So it is not just collecting the data; it is also studying the behavior and then giving inputs, which is one step ahead.
Thank you so much for the question, my lord. Firstly, your leadership, I would like to differentiate between the metadata versus the content we are doing in this project Nigrani. Basically, in respect of live recordings, it captures the subjective content of what is being said. Basically, there is a private discourse that we are recording the particular recording. While the real-time interception, it captures the fact of the communication. Like also under Project Nigrani, focuses on the signal intelligence, which basically tar the phone pinched or at basically at what millisecond or at what particular area the phone was pinched in a particular area, while a recording invades the inner while in a recording, live recording, it invades the inner sanctum of the mind. Interception of location metadata, which is under Project Nigrani, it basically merely tracks the physical conduct in public space. If a phone pings a tower at a
The tower thing you're telling, that is by exploiting the vulnerabilities in the cellular towers or cellular infrastructure. Apart from this, what are the various methods to which you can do this real-time telephone data interception? Because this is very detailed, right? Like live conversations are being recorded. It is not just that you just take one location of the cell phone in one cellular location. It is much more than that. So when you have to record the telephonic conversations and messages, etc., what else is the method involved here?
Thank you for the question, your leadership. Leadership in this particular scenario, the least intrusive method can be basically the state requests. Basically, the state can request the call detail records or the tower dumps from basically the service provider, and basically
so this is live. See, you just particularly choose a target, and then you choose his cell phone. You do the live monitoring. So it is not just from the tower. When you identify an individual, even spyware and malware could be installed in order to gain access to the person's phone. Isn't that correct? With due permission of your lordships, I would like to inform the estimated time given by the speaker is already over.
If I may answer the question, and I would like you to take 2 minutes of the time. Your leadership, to answer your question, basically the spyware or the malware, it involves a hacking a device to take the control of its camera, microphone, and all the encrypted files. But in this particular scenario, we are only utilizing it for the lawful interception. In this also scenario where there was no direct evidence provided, where there was no witness, no entry was able to get from the evidences, and in this particular scenario, we went to the indirect evidences, which was from the telecommunication. And as
no, counsel, the question is, your particular project involves collection of live data, and the executive or the person who is doing the research, or who is involved in this, he would be live monitoring and could collect any of this data that I just mentioned, even install a malware or spyware, right? Maybe it may or may not be in this just this particular case, but the authority given to the executive is violating the rights of the people at large, because anybody can access anybody's phone, install spywares or malwares, collect their live telephonic conversations, right?
Your leadership, in the Project Nigrani, when we are saying live, we are only referring to the real-time location information. Basically, in an investigation, the state must know where the suspect is. Now, to prevent an escape, if the police is chasing a murderer down a street, it is a live chase. But if the police are chasing through a digital footprint, through cell towers, then it is basically simply a technological aided chase. Both are valid under our CRPC, and also as the algorithm identified a device and the face at the crime scene that matched a high risk behavior profile, we did not choose the individual. The individual's physical presence at the crime scene chose them for the particular investigation. And also,
I agree. he was present near the crime scene, right? But you involved in real-time telephone data interception. Am I correct?
Yes, Your Ladyship.
What does that mean?
Data interception.
It is not just taking details about the tower and where his mobile phone was. It is much more than that. Real-time data interception. That means live recording of his conversation also, and what he was doing on his phone.
Yes, Your Ladyship.
That is a blatant violation of his right to privacy.
With your due respect to
So
Ladyship.
tomorrow, if I was suddenly walking near some place and then suddenly realize that there was something happening near that, suddenly all of our phones in the vicinity could be checked and we could be heard. That is a concern.
I understand the question, Your Ladyship. Ladyship, I would like to answer. I again repeated that when we are engaging in the real-time telephone data interception, we are not listening to a live. We are basically mapping a crime in progress in the context of Project Nigrani and the assassination of the police commissioner. It means that the real-time interception, the state receives the
It is not just the real-time, finding out where the mobile was in which tower. It is much more than that. The term is called real-time telephone data interception. Okay.
Yes.
Madam, one thing. Don't you think that Puttaswamy is not staring at you in this scenario? Whatever support you received from R.M. Malkani's case, 1973 1 SEC 471, that has been overruled by Puttaswamy. See, you have created a project out of nowhere. No provision of law, no legislation, no gathering of public opinion, no consultation with a larger constituency, no debate or discussion in the parliament, and you are armed with Henry VIII power, Henry VIII clause, like removal of difficulties. Then your duty to take care is all the more important. It should not only be done, it should manifestly and undoubtedly be seen to be done. That is where you have to answer. That is where you have gone, I think, wrong.
My lord, I must respect.
To be very sincere, honestly, can you say that his filing of bill never influenced you in prosecuting him? So, while exercising such drastic draconian power, there should be reasonableness to the core, not merely evidence-based reasonableness. That is what you have.
Thank you so much for the question, my lord. The respondents, we is the first to agree that the reasonableness is the bedrock of Article 14. However, we must actually distinguish between the reasonableness of the state's duty and the reasonableness of the petitioner's apprehension. Here, the petitioner is arguing that filing of PIL should grant a form of immunity or a heightened reasonableness in the surveillance. But filing a PIL is a democratic right, but it does not create a protected zone around an individual's physical conduct. If the law were to say that the activist or the PIL litigants cannot be monitored by objective algorithms, we would be creating a privileged class of citizens who are above the digital scrutiny, my lord. And it would be the ultimate violation of Article 14 as well. But if we refer to the judgment of K.S. Puttaswamy as well, I also must respectfully submit that firmly contest the characterization that this is infringement of the personal. We must distinguish between personal privacy and personal conduct. My My lord, the state is not peering into the inner sanctum of the petitioner's private thought. We are analyzing the transactional metadata. A phone connecting to a cell tower is a public act of using state regulative infrastructure, as also held in K.S. Puttaswamy. While privacy is a right, it is not an absolute shield that allows an individual to remain invisible while moving through public or digital spaces, especially during a decapitation strike or the state's law enforcement. And also, my lord, the Project Nigrani does not look for a person, it looks for the anomaly. The real-time data, as also mentioned by my ladyship, is fed into the mathematical black box. No human officer sees the petitioner's personal data until the algorithm confirms with mathematical certainty that the device's physical behavior matches the logistic of the crime scene. And my lord, this is far less intrusive than a physical stop and frisk. The machine has no interest in the petitioner's personal life. It is only interested in the geographical intersection of his device and, in this particular case, the murder of the commissioner. If I may...
Just to, you are saying that you're not interested in person and all those things. So, this project directly studies or analyzes the behavior. In fact, the conviction is based on the behavior aspect. There, the surveillance is undertaken and the behavior is studied, and based on that, a conviction has been given. So, therefore, analyzing or studying a person's behavior, because a man is known by his behavior, it is very private. It directly infringes privacy. It is worse than actually surveilling a person's house, because at least surveillance will stop at the person. Because if you analyze the behavior, a person, he goes anywhere, it's the behavior that matters, and the behavior is also not static because it changes from place to place. So, does it not directly infringe the privacy, because this project tries to analyze, study the behavior and come to a conclusion in assuming the guilt. And also that when you are convicting a person, the standard of proof must be much higher, because he's been charged for an offense such as murder. So can a person be charged for such a heinous offense based on just a digital surveillance?
Thank you for the question, Your Lord. I would like to answer by stating that the Project Nigrani, the algorithm, it does not look for the petitioner's habits, hobbies, or personality. It filters for the temporal anomalies, basically. If 1,000 devices move in a predictable baseline pattern and one device moves in a high-risk trajectory, such as lingering in the restrictive high-security zone at the exact moment of the strike, that is not a study of behavior, my lord. It is the identification of a tactical outlier of a person. So this is what we are talking about, the ultimate reasonableness. The state is not monitoring the person. It is only monitoring the event. And also, my lord, a human officer might target a dissenter because of the political bias. But an algorithm, however, is blind to its identity. The behavioral input the system receives is purely numerical, coordinates, timestamps, and an analysis. The machine has no concept of PIL or of a researcher. It only flags the physical footprints that intersect with that particular crime.
So, Counsel, do you mean to say AI in general does not try to understand the people's background and then analyze it in the further future situations? I mean, that is what the chat GPTs do, right? That is why we call it as artificial intelligence. And if you feed something on one particular situation, 15 days later, you ask that particular AI to generate some letter or something, it will include the information provided previously.
Thank you so much. Thank you for the question, my ladyship. My ladyship, I would like to answer the question by stating that human investigators often understand the background very well, leading to a bias.
In fact, a human investigator may forget things, but not the AI.
Yes, my ladyship. But the AI in Project Nigrani is identity blind.
So you mean to say that this particular AI there are certain restrictions placed on it, that it is not supposed to collect the data and analyze it in the future situations? Then what is the use of this AI? Because if you're trying to track a criminal history, then how can you even use this particular AI?
My leadership, I would like to answer that particular question. That by ignoring the background and focusing on the behavioral anomalies, the AI basically creates a classification based on the risk and not on the personhood of that particular person. It treats all the citizens as equal data points until their physical actions. The physical actions is what that differentiate them.
Let's say there are some 5 people who were there in that particular vicinity, and in that particular case, just 2 of them were held liable or guilty. Then subsequently, there is some other case wherein it is somewhere related to people's present in that vicinity. So, will the AI consider all these 5 once again, or it will just forget that there were 5 people previously?
Thank you for the question.
Did you understand my question? If there were 5 people in that vicinity, and in that particular case, only 2 of them were held liable, subsequently there is another scenario, another case coming up, will that remember that in that previous case, there was 5 different people who were there in that vicinity? Will it go back to its records?
My leadership, if 5 people were previously held liable or flagged in a similar vicinity or the context, the AI will not only remember them, but it will use that data to perform basically a relational analysis. So here,
so all the 5 people who were there in that area, it has detailed analysis of all the 5 people, right? Whether it was needed in that case or not needed.
The leadership, so AI.
That exactly is the problem here.
I would like to answer the question that AI functions basically the historical pattern recognition, as you also mentioned. If those 5 individuals were involved in a prior incident, their device IDs and facial profiles are already characterized within the high risk or the known associate database. But the moment they appear in the vicinity of a new crime, the AI does not start basically from zero. It triggers an alert of that particular person and linking their current presence to their prior history. So if the AI, if these 5 people who were previously held liable are found together again in a new crime scene, then the AI will recognize them as a they can held liable as a
So if in detail, if you're doing this analysis, that means you will need more authorization. That is exactly what I'm just trying to hint here. Because the kind of assessment that you're suggesting, it is very thorough, very detailed. And even those people who are innocent and who are just randomly walking around in that area, even their phones, there are chances that you will collect entire, data available on their phones. So hence, I'm telling you that you needed further amount of authorization rather than just one executive order.
Yes, right? But although, as I also mentioned, that this executive notification was not entirely at yet, it's also coming from the information technology, and it was also coming from the Telegraph Act, which is basically repealed, but now it is Telecommunication Act. And also, I would like to state that this system is acting as a mathematical sleeve kind of. It is not a bucket. While the network handles large volumes of data, the interception only occurs for those who match only a specific size and meaning. An innocent citizen's data remains as an unread. The AI will not read the particular person's data. It is unless a person's physical content matches the digital fingerprint. In this scenario as well, Ayan Qureshi, even though he was a researcher and an activist, but as there was no evidence found by the investigating officers, and just because and as it is clearly mentioned in our memorial as well, that the facial recognition cameras capture the petitioner near the police headquarters before the estimated time of death. The telecom metadata placed his mobile device in the vicinity. The predictive algorithm classified him as a high-risk suspect, and on the basis of behavioral and also the online activity analysis. And so in this particular scenario, what I am trying to say is that for the 99% of the population who are innocent, they're nothing more than a statistical baseline. The AI is programmed to ignore those normal behaviors. The privacy is not violated if the machine sees a data point, but zero.
Okay, answer. You may proceed. You may proceed, please. You've got your answer.
Thank you so much, Your Leadership. Thank you so much, Your Leadership. If I may state the conclusion of issue 1 and 2. Much obliged.
Quickly sum up your second issue.
Sure, Your Lordship. Sure, Leadership. Your Lordships, the petitioner contends that the admission of such evidence would violate the right of fair trial, as I also clearly mentioned earlier as well. While the settled position of the law is that the relevance is the primary test of admissibility. This position has been authoritatively settled in earlier cases as well, but the petitioner seeks exclusion solely on the basis that the method of collection is allegedly improper. However, Indian law has consciously not adopted the doctrine of the fruit of the poisonous tree. In this present case, the evidence obtained through the Project Nigrani directly relates to the alleged offence involving Nyaya Shastra and forms a part of the same chain of circumstances. Even assuming, without admitting, but there were procedural deviation that alone does not render the evidence inadmissible. And also, my lords, 63 and 65 of Bharatiya Sakshya Adhinam states that 63 recognizes the electronic records as admissible evidences. 65 requires authenticity, but in the present case, there is no inherent challenge.
Patil, you prosecuted the accused under which offence? Which code?
If you may pardon, my lord.
You prosecuted and convicted the accused and the petitioner under which law? Under which penal law?
The accused, basically Nyaya Qureshi, we are prosecuting for the most grave offence under the section 302 of Indian Penal Code.
So, which evidentiary law will be applicable?
And we know that Indian Penal Code has been repealed and now it is Bharatiya Sakshya Adhinam. But if I want to tell the sections of Bharatiya,
In a trial of an offence under the Indian Penal Code, which law would apply as far as the evidence is concerned?
The Evidence Act, the Bharatiya Sakshya Adhinam, my lord.
Both. You said both.
The Indian Evidence Act or the Bharatiya Sakshya Adhinam, although right now we are.
Give me one answer. Don't say all.
Bharatiya Sakshya Adhinam, my lord.
The Indian Evidence Act won't be applicable.
Because the Indian Evidence Act, and now it is Bharatiya Sakshya Adhinam.
When did the offence take place?
In 2022.
Which law was applicable then?
Indian Evidence Act, but the case we are doing it is right now, which is in 2026. So we will apply the Bharatiya Sakshya Adhinam.
The law as on the date of the offence, alright, as on the date of the act, that would be applicable. And you have already concluded the trial, right? You have concluded the appeals. Now you are before the Supreme Court. So naturally you will refer to the repealed act, which would still be applicable in these cases, not the Bharatiya Sakshya Adhinam.
Thank you for the answer, Your Lord.
Your time is up.
If I conclude, my issue is 2 lines. Therefore, Your Lordships, the evidence is relevant and probative. It is not hit by any principle of self-incrimination and it satisfies the statutory requirements and its exclusion would defeat the justice. While, Your Lord, the executive action is constitutionally valid, the project serves a legitimate and a necessary state purpose and it represents a visible exercise of power in the evolving circumstances. Much obliged to Your Lordships. If I may allow my co-counsel to address issues 3 and 4. Thank you. Lordships, my learned co-counsel has addressed on the issues 1 and 2, and I shall now address on issues 3 and 4. The constitutional validity of algorithmic profiling under Articles 14 and 21, and the question of whether this honorable court ought to interfere with the concurrent findings of two courts below. My lords, before I proceed, I wish to place one foundational proposition before this bench, a proposition that will govern everything that follows. My lords, the police commissioner was assassinated inside his own headquarters. No weapons, no witness, no trace. The only thing that stood between justice and impunity. The petition says that machine cannot be trusted. The respondent asks, trusted less than what, my lords? Less than nothing. I shall demonstrate this with the precision. My lord, I draw your attention to issue 3 as addressed at pages 18 to 22 of our memoriam. The petitioner's entire attack on Project Nigrani's algorithmic profiling under Article 14 rests on one word, opacity. The algorithm is a black box, they say. It is arbitrary. It violates equal treatment. I invite your lordship to examine what the alternative is. The alternative, the traditional alternative, is a police officer, a human being with some biases, maybe embedded over a lifetime of experience, with a fatigue at 2 a.m., with community prejudices, with institutional loyalties, with the capacity for deliberate, malicious, or subconscious discrimination. My lords, the jurisprudence of this very court is replete with cases where human investigative discretion reduced exactly the arbitrariness that Article 14 consents. Now, Project Nigrani replaces human discretion with a system that I use these words with technical precision, has no fatigue, harbors no personal animus, applies identical parameters to every data point it processes, and cannot be bribed, intimidated, or politically pressured. My lords, which of these two systems is more arbitrary? Which one violates Article 14? The Honorable Supreme Court in State of West Bengal versus Anwar Ali Sarkar held that the test of Article 14 is whether the classification is based on an intelligible differentia with the rational nexus to the objects were to be achieved. My lords, the intelligible differentia is the quantified algorithmic risk threshold. Every individual above that threshold is treated identically. Every individual below is treated identically. That is not discrimination. That is, with respect, most mathematically pure expression of equal treatment this court has ever encountered. The petitioner learned counsel will likely rise and say, but the parameters of the algorithms are undisclosed. My lords, if the petitioner demands that the state disclose the precise weightings error thresholds and training data sets of the predictive threat analysis unit in open court, then the petitioner is asking the state of Dakshin Pradesh to hand a detailed technical manual to every sophisticated criminal in this country on how to mathematically launder their digital footprints and evade the detection. My lords, that submission rests in the language of constitutional rights is in substance a submission that the state must disable its own security architecture before it may use it. The Honorable Court might not countenance it. So, as this court noted in Barium Chemicals Limited versus Company Law Board, state action based on systematic data-driven methodology naturally meets the standards of a determinate principle. Project Nigrani's risk calculus does exactly that. Your Lordship, on Article 21, the petitioner invokes Maneka Gandhi for the proposition that procedure must be fair.
Madam, one question. In all these authorities which you have cited forcefully, starting from the Anwar Ali case, there were legislations to be interpreted. Legislations enacted by competent legislature was there to be interpreted. Here, what is the research you have done for formulating this Nigrani? Have you traveled beyond India in other countries where such systems are there? What is the research what is the consultation you have done? You have taken power into your hands. Then you say that Article 14 is. See, after Maneka Gandhi's decision, there is no much relevance for classification and all. It is arbitrariness, which is a touchstone. What do you say?
Thank you, Lordship, for your question. I would like to answer this by saying that the research grant and the travel of this topic, I offer three chances for that. So the research and formulation of Nigrani are grounded under Article 162 of the Constitution. So this article mandates that the executive power of the state is coextensive with its legislative power. So the logic behind that is when the state faces a decapitation strike, like the murder of a commissioner, it does not need a new grant to use modern law. It uses its inherent police power to protect the right of the life. Now, Project Nigrani is not an isolated experiment. It follows the global standard of algorithmic governance. So the doctrine has indeed traveled. So as far as I know,
It is not an isolated document, but you have made yourself isolated with the method in which you have created this. That is the problem.
Your Lordship, I think
Also, Council, you expressed that there is an urgency to implement this particular project, right? And you justified that there are others also, like there are people who are trying to do it unethically or illegally. So, don't you think justice hurried is justice buried? And you're trying to hurry and trying to implement something like this by your own volition, there is greater injustice that will be caused. You should have rather consulted experts and tried to involve, as Honorable bench also pointed out. It would have been, yes, it would have been more authentic if you would have consulted the other organs as well.
thank you, leadership. I would like to, as your Lordship asked, the global standard of algorithmic governance.
Madam, Constitution bench is examining these reference questions, not purely in the context of this petitioner or appellant. This bench is examining this provision, how you got this power, how you created this jurisdiction, to what extent there are possibilities of misuse, abuse, unreasonableness. So these are things which you have to explain before the bench.
Your Lordship, thank you for your response. I will further take it in my arguments, but as of now, I would like to say that in the digital age, the evidence is volatile. So metadata and digital footprints can be deleted or overwritten in seconds. An urgent response to precise response. Project Nigrani allowed this to
Definitely yes, but you need to have some authority to do that. Not everybody can randomly take the responsibility of collecting the data.
Just
If
to
not,
add
then
on,
what is the difference between some hacker sitting somewhere and you? The police and some random hacker somewhere are no different in that case.
in fact, you say digital data or the algorithms, whatever it is far more safer than a police service. You are attributing that there won't be an aspect of bias insofar as digital data is concerned or the digital surveillance is concerned. Whereas you yourself have agreed that it can be deleted, manipulated. So, isn't the police, the authorities, doesn't it have the power to manipulate digital data because it is exclusively in the domain of the state and there is no safeguard. There is not there. There is nothing. So anything presented as data, if rightly is accepted, and anybody and everybody can be convicted. Everybody is almost like a dictatorship where the state is having the power to implicate anybody and everybody based on a data without any procedure or technical safeguards.
Thank you, Your Lordship. So, my Lord, to equate the sovereign state with a hacker is not only legally, it's so there is a fundamental irreducible differentiation between cyber criminality and digital governance. So, acts with malified intent to disrupt, extort, or steal, their actions have no basis in the law and serve no public good. So, the acts under the
See, what if there is this person amongst the citizens who really intends well and he starts taking things in his hand? A well-meaning citizen starts let's say he starts surveillance on every other individual by using hacking, right? So you cannot say that the police, and also when you say sovereign, you will get the sovereign authority when you're trying to do you're trying to implement this project with proper authorization, and unless you have any law or unless you have any authority yourself, how can you call yourself sovereign implementing this?
Thank you.
Just because he's a police official doesn't mean he gets right as it is. He need to have some proper authorization.
Thank you, Your Ladyship. So, on the well-intentioned citizen is the exact person Project Nigrani is designed to protect. So, the petitioner, the argument assumes that surveillance is a weapon used against the people, but the respondent contends it is a shield for the virtuous. So now, good citizens will feel watched and their privacy will be chilled. So, Project Nigrani does not watch people; it filters.
Are there good citizens and bad citizens?
Sorry, Your Lordship.
Are there, you are referring to good citizens? Are there good citizens and bad citizens in our country?
How do you classify citizens as good or bad?
In the eyes, it's not about bad citizen or a good citizen. In the eyes of Constitution, my lord, there are no good or bad citizens. There are only law-abiding citizens and law-breaking enemies. So to allow state to categorize citizen based on a moral good or bad binary would be the ultimate.
Madam, Constitution does not monitor the citizens. Constitution monitors the government, the power. Constitution is monitoring you, not us, not the citizens.
Yes, my lord. That is definitely a profound constitutional truth. The Constitution of India is indeed a charter of. It tells the state what it cannot do to the citizen. However, we must not confuse the function of a citizen with detecting a crime. So, as the respondent, Project Nigrani is not the government monitoring the citizens. It's the government monitoring the primary constitutional duty. Protection of rights. Life under Article 21 is not just the right to be left alone. It's the right to be protected by the state. So if the government refuses to use the best available technology, Nigrani, to find the killer, it is violating the Article 21 rights of every other law-abiding citizen by allowing a murderer to remain at large. Now the Constitution protects the inner sanctum of the home, but it does not grant a right to absolute digital invisibility on the public records. So the spectrum, the cell towers and the satellites are public resources regulated by the state. So when a citizen uses a mobile phone, they are broadcasting their location to a tower. So the state is not breaking into the citizen's mind; it is merely observing the logs of its own infrastructure. So monitoring.
And now you're justifying what you have done. You're justifying what you have done, and you say that they are the ones who are allowing us. Do you think it's an invitation? Do you think using cell phones is an invitation into our private lives? Isn't it what you're trying to tell? You say the cell phone, according to your argument, is an invitation for the government into our private lives. Is that what you're trying to tell us?
No, Your Ladyship, the justice.
Exactly what you were explaining right now.
Your Ladyship, it is respectfully submitted that mere use of a mobile phone cannot be treated as an open invitation for state intrusion into one's private life. However, it is equally well settled that the expectation of privacy is not absolute and varies with the natures of the information involved.
Counsel, you just when before me posing this question, you were trying to tell me something. I mean, tell us something that the citizens, by using the telephone, they are that using the mobile, they are trying to connect to the tower, and they are the ones using their.
If you may pardon, you're muted, Your Ladyship.
Hello, am I audible?
Yeah. Can you please repeat your?
Yeah, I'm just referring to your argument before I pose the question.
Okay, Your Ladyship. So in the present case, the state is not accessing the content of private communication, but only limited telecom data, such as location and routing information, which is inherently shared with service provider in the ordinary course of using a mobile network. So therefore, the user's expectation of privacy in such data is significantly reduced, and any minimal intrusion must be balanced against the compelling state interest.
Council, if you may refer to the fact sheet, what is the kind of data that you're collecting?
So basically, it is the facial recognition camera. It captures the petitioners near the police headquarters shortly before the estimated time of death.
What is the kind of data that you're collecting through this project?
Through this project, we are actually collecting the. We're not collecting the private live data. We're collecting the network intelligence. So this is
what is the nature of the information gathered?
The call data records, the cell site location information. So
read from the fact sheet, please.
So, sorry, Ladyship.
Can you please read it from the fact sheet?
Yes, sure.
Paragraph 2, if I may ask you to read the second line, second sentence.
The project created an extensive digital surveillance architecture consisting of facial recognition camera installed across Nagpur city, automated number plate recognition system, real-time access to telecom metadata, and a centralized predictive threat analysis unit using machine learning algorithms.
So as I asked your co-counsel as well, real-time access to telecom metadata. What do you mean by that exactly? Telecom metadata. Have you tried to understand this?
Yes, Your Lady.
So you're misguiding the code by saying that it is just trying to locate the tower from where the mobile was found. You're actually misleading the code.
The leadership in the context of Project Nigrani, real-time access to telecom metadata refers to the instantaneous acquisition of the logs of a communication rather than the audio
mentioned there.
Has
that limitation been mentioned there? Because here it has been stated in paragraph 2 that in 2022, the state of Dakshin Pradesh, in collaboration with Union Ministry of Home Affairs, launched the project Nigrani, and then these are all the things that these are all the data that is collected by through this project. Real-time access to telecom metadata. What does it mean? Why does it say real-time access to telecom metadata? What do you mean by metadata? Is it restricted to where exactly, in which cell phone tower the mobile phone is seen? Does it mention that?
Thank you, Your Ladyship, for your question. So, in the context of Project Nigrani, we are defining metadata as to the who, when, and where. So, metadata is data about data. It describes the properties of a communication without revealing the actual substance of the conversation. If a telephone call is a package, metadata is shipping label on the outside. So,
Okay, counsel, let us agree that they're not collecting any other detail. Then how exactly is this AI trying to recognize the likelihood of committing serious offense? If you're just collecting the data as to where this person is, so there are hundreds of people who are there in that locality, and how exactly is this AI of yours trying to understand the possibility of committing serious offense? Is this just by the presence in that locality?
Grateful for your question, Your Ladyship. So
just to further the this AI collects data and then based on the data gives input. Right. Say for example, if I want to have Chinese food, I keep searching Chinese food on my mobile. The AI will, after a few days, will give me with all recommendation the nearest Chinese restaurants which serves Chinese food. The same thing. In this case, this person, the accused, was an anti-Project Nigrani activist. He was actively campaigning against it. So all his activities, everything related to this thing. So the possibility is that it would have searched or his behavior would have indicated anything which might be aggressive, or even another one step further. The person who is actually analyzing a behavior who has anger against the entire project, it might show his anger against a particular individual. Say for example, the victim or the deceased in this case, where he might be aggrieved against the commissioner. He might have searched about the commissioner. He might have written letters to the commissioner. He might have spoken bad about the commissioner, which does not in any way implicate or indicate the fact that he was going to murder the commissioner. At best, he would have some bad opinion or bad things to say about the commissioner. He would have bad mouth the commissioner, which does not in any manner indicate that he would be murdering the commissioner, which AI will presume that he has murdered the commissioner. How does
And
isn't the AI biased then, as what ma'am rightly pointed out?
And if I add to it, definitely the AI could have studied the messages as it means that the real-time interception of metadata, telecom metadata, the SMSs and WhatsApp message sent to his family members or maybe his friends could also be taken or read by the AI. And that is how it has come to a conclusion about committing serious offense. Now, both the ways you have to explain it to us, because if you're not considering any of these data, how exactly did the AI come to conclusion that he is going to commit a serious offense? And if it has collected all this data and then come to a conclusion, then what authority did you have? Because not just him, everybody around in that vicinity, it has to study all of them thoroughly and then come to this conclusion. And if it has not studied all the other people as well, then it is committing arbitrariness because it is targeting one individual based on some reason we don't know.
Thank you, Your Ladyship. I would like to answer.
With due permission of your lordships, I would like to inform the speaker that your given time is already up.
If I may take 2 minutes to address both of the questions.
Yes, please.
So, my lords, with utmost respect, the analogy is fundamentally distinguishable. Merely searching for something on an AI platform, such as you mentioned, the Chinese food, may generate recommendation, but that alone does not result in an adverse legal consequence. So, in the present case, the petitioner was not identified or acted upon solely on the basis of isolated digital activity or expression, such as being an activist or researching a particular subject. So, my lord, the question of WhatsApp messaging brings us to the front. It's an end-to-end encryption debate. So, as a response, state is not breaking encryption like a hacker. It is exercising the statutory right to information mandated by Parliament to safety of the Republic. So the state's authority to interpret or trace these messages is not derived from a secret project, but from information technology intermediary guidelines and digital media ethics code. Rules 2021. So the traceability mandate. So significant social media intermediaries like WhatsApp are required to enable the identification of the first originator of the message. So now the power can only be used for the prevention, investigation, or prosecution of a serious offense, specifically those related to sovereignty of India or public order, like the murder of the commissioner here. So we must apply the threefold test of K.S. Kutta's one to justify this access. So the power is explicitly provided in Section 69 of the IT Act and the 2021 rules. So the legitimate aim is not to read private chats, but to identify the source of a conspiracy that led to a decapitation strike on the state's police force. Now the state does not ask to see the content of all 1.4 billion citizens' messages. It only seeks the first originator of a specific message linked to the crime. So this is a surgical intervention, not a bulk sweep. So the respondent contends that interpreting a message does not always mean reading the text. So even without breaking encryption, the state can do prevent unlawful. If a specific digital site, like a blueprint of the is circulated, the state can track the hash, the digital foot fingerprint of the network without ever needing to decrypt individuals' personal messages. So, my lord, privacy is a right to be left alone, but it is not a right to plot an assassination in the shadows of